Today, in Acme Limited and GL Enterprise, I hold that the parties' express choice of German law to govern the dispute does not prescribe this honorable court from hearing this case. On the authority of the Fairman's principle, the party's choice of law is not decisive. Thereby, I dismiss the claimant's application to stay the proceedings.
I will exercise my right and appeal.
I hereby reverse the High Court's decision that the party's choice is not decisive. Conversely, I hold that the German law should apply as per the party's express choice. I rely on the eleftheria approach and grant the application to stay the proceedings.
Good day. We are from Group 16, and our challenge reads the absence of a settled principle to decide on the matter of foreign jurisdiction clauses. Preliminarily, a foreign jurisdiction clause refers to a clause which sets out the parties' agreement to submit their disputes to a particular forum. Such a contractual provision is an almost indispensable prerequisite to achieve uniformity and predictability, elements which are essential to any international business transaction. Two landmark cases under this subtopic are the Fairman and the Eleftheria. The Fairman does not give regard to the agreed clause between the parties. This was based on the reasoning that no one by his private stipulation can oust these courts of their jurisdiction in a matter that properly belongs to them. Regard must also be given to the country with which the dispute is most closely connected to. Conversely, the Eleftheria propounds a presumption of grant of stay of proceedings. The case will be stayed in honor of the freely negotiated clause, unless the plaintiff proves a strong cause for bringing the action before it instead of the agreed forum. The strong cause requirement is guided by 5 factors that have been listed on the slide. Taking a critical view here, it can be said that the Eleftheria has in fact been deciding along the reasoning of forum non-convenience.
Now, we will be analyzing the Malaysian cases on foreign jurisdiction clause. Firstly, Global Shipping and Typing Textiles, which was decided by the Federal Court in 1976. The case referred to both approaches and decided to follow the Eleftheria approach. The principles were an exclusive jurisdiction clause could not deprive any Malaysian court of jurisdiction over a matter that was properly belonging to them. Moreover, if there is an express exclusive jurisdiction clause, a compelling reason must be made to justify the departure. The courts have the power to grant a stay of proceedings application in accordance with the exclusive jurisdiction clause. Moving on to the case of Elf Petroleum, which was decided in 1986 by the High Court, the case adopted the Fairman approach. Parties agreed that Singapore law shall govern any dispute, but the choice of forum clause does not oust the jurisdiction of the Malaysian court. So this case was decided in Malaysia. Moving on to the third case, which is the Sabah Gas Industries, which was decided in 1993 by the High Court. Malaysia decided to follow the Eleftheria approach. The case was not heard in Malaysia since the plaintiff could not prove a strong cause.
Fourthly, decided in 1994, Seloga Jaya and Pembenaan Kangtin, the Supreme Court cited the Eleftheria and mentioned that strong grounds for refusing a stay must be exhibited by a plaintiff. Next, in American Express decided in 1995, there were no peculiar difficulties which the respondents would face, so the Supreme Court followed the Eleftheria approach and held that Singapore is the more suitable forum. Therefore, even after a court has made a positive ruling on jurisdiction to hear a claim, it can still exercise discretion to allow the application of a party to try the case according to the forum non-convenience principle.
Moving on, in this 1995 Court of Appeal Inter-Maritime case, there was a clause provided that the contract was governed by Japanese law, but the respondent issued an action in Malaysia. At the end, the Court of Appeal referred to both Fairman and Eleftheria approach and decided to reject the stay of proceedings, hence not giving any effect to the forum selection clause because there were stronger links on the facts of the case with Malaysia, despite them agreeing to hear the case in Japan. Moreover, in this recent 2019 World Triathlon Court of Appeal case, the parties entered into an agreement where if there's any dispute, it will be in Florida, US. But the respondent commenced a legal action in Malaysia. The High Court dismissed the appellant's application for a stay notwithstanding the exclusive jurisdiction and governing law clauses. This was reversed by the Court of Appeal that adopted the Eleftheria approach. This demonstrates our courts are willing to uphold the pre-agreed exclusive jurisdiction clause for dispute resolution. Moving on to the justification, which strengthens our choice of challenge. The indecisiveness in the approaches would firstly lead to a waste of litigation to decide on the laws, especially in appeal cases that are based on the approach being used. This view was further corroborated by judges in India who opined that settled legal principles should be applied by the courts to avoid the unnecessary rounds of litigation. Secondly, when multiple courts have different jurisdictions over an issue, it would lead to forum shopping and it would make law unpredictable.
Lastly, there's an absence of a patent structure. A settled law serves an important structural role. However, this is absent in the decision-making process of foreign jurisdiction clauses as there are more than one principle involved. courts of the same level adopting different approaches like in Elf Petroleum and Sabah Gas enhances this analysis.
Next, we prefer the electoral approach as firstly promotes a fair balancing of the factors to determine the appropriate jurisdiction. Further, it honors the agreement between parties by acknowledging the foreign jurisdiction clause, and it is a more reasonable test as there is a presumption of stay. Moving to the criticism of Firman, the Firman approach is parochial as it assumes jurisdiction in the face of such submission. It may also be used to avoid enforcement of foreign jurisdiction clauses. Finally, it imperils the willingness of parties to enter into international commercial agreements. In conclusion, the patent inconsistency in case law pertaining to the adopted approach may potentially put the court in bewilderment, and that is precisely why we advocate for one settled principle. Accordingly, the conflict of law principle adopted in Malaysia pertaining to foreign jurisdiction clauses will be uniform. That's all from us. Thank you.